Welcome to Lowndes Legal Talk, where we share perspectives on legal and business issues affecting you.
Good afternoon. My name is Drew Sorrell, and I'm a commercial litigation partner at the Lowndes firm in Orlando. With me today is Morey Raiskin. Morey, say hello.
Hi, I'm Morey. Thank you for watching. I am a management, labor, and employment lawyer at Lowndes. I've been practicing for 38 or 39 years.
And Morey and I have been talking and reading in the newspaper where there's been quite a bit of discussion about liability with respect to COVID. And that liability is kind of in two parts, which is the first part is whether and if there's liability for employers with respect to their employees. And then a second part of that is, and we'll talk about this later, is the question of whether or not there's liability on the part of, for instance, a shopkeeper and their clients with respect to COVID. So, Morey, what do you think? Is there liability?
I believe that there is definitely going to be, and already has been, significant numbers of filings of workers' comp related claims for employees who have worked and contracted the disease and have sought recovery. And I think that it is an open book as to whether or not, depending on the state that the employee is in, whether or not that will or will not be covered as a workers' comp event. How about you, Drew?
Well, I think there can be. And with all good lawyers, we refuse to actually commit to any one thing. But I think the answer is there can be, and there's quite a bit of variety in what those claims can be. So for instance, I think you have, and we can talk in detail about this, but I think you've got potential liability under not only workers' comp, but I think you've also got liability perhaps under different themes of what I'll call old school laws that have been around for a long time that really have nothing to do per se with COVID. Again, you've brought this up in other conversations we've had, but with respect to, for instance, the AIDA or age claims.
Right, and I think another one to be sensitive to is possible national origin claims. But I do believe that it from an employer's perspective, it's either workers' comp, tort liability, or discrimination. And an employer has to be vigilant about the potential of all three types of claims.
So just to kind of play that out a little bit, you've got on the one hand tort liability, and on the other hand you've got work comp liability. Tort liability is what you think of as a traditional lawsuit in a court in front of a judge. Workers' compensation liability is probably ubiquitous and fairly well known to people at this point, but that's an administrative process where an employee enjoys certain benefits with respect to injuries that they suffer on the job site. So far, so good?
I think so.
Okay. And under the traditional, holding aside COVID and not talking about that for a minute, most employees, if they're injured at work, are going to go under workers' comp, and employers are going to have, in essence, 100% liability, and I'll put an asterisk next to that, for that injury. And on the other hand, in exchange for that coverage, the employee gives up the right to sue the employer in tort, meaning for a civil suit. What that does is gets essentially medical coverage and other compensation for certain types of injuries. But you give up the right for punitive damages and certain other extraordinary remedies is what we would call them in court. So that's kind of the general balancing act that you have in this area. The question then becomes, well, how is that different for COVID? What do you think?
And I think it hinges on whether or not conditions or illnesses are covered under workers' comp, or whether the law of a particular state excludes that from workers' comp coverage, because workers' comp coverage traditionally has been for a quote unquote accident at work.
And to that point, Florida does have a case law decision that has set forth a test I'm not going to walk through all the pieces of the test, but the very short version of what the test is with respect to a disease that you suffer or become affected by as part of work, you have to demonstrate that that is, and again, my words, not the actual test, that that's something that is special to you, that you suffered from work, and it's not something that the general population would suffer from. So for instance, the flu is probably not going to be covered under work comp. COVID is a little bit of a different animal in the sense that you have different classes of workers de facto, meaning you've got essential workers and then you've got non-essential workers. And you can make the argument that a essential worker is now faced with dealing with more people, and that's different than what the average citizen would be faced with. And so you have an argument that there's now coverage under work comp. Not to get too deep into work comp, because neither Morey nor I, as a regular practice, are work comp lawyers, but that's kind of the general setup. So that kind of raises the second question. Let's assume that you're not covered under work comp, and that you as an employee want to proceed against your employer under a civil filing in tort. What do you think about that, Morey?
I think that if you are trying to avoid the workers' comp exclusivity, which employers and really most everyone focuses on, then I think that it will depend on the allegations of your complaint. And if what you want as a claimant is the opportunity to present your claims to a jury as opposed to an administrative law judge, then I think you're going to have to allege some type of intentional or willful conduct on behalf of the employer, or some type of reckless disregard that exposed you in a way which was beyond what you would regularly think of as a workplace situation.
So like a gross negligence standard is what you're referring to.
Right. And when you take a look at the several cases that have been filed in places around the country, I think the allegations are clearly set out to anticipate and then try to defeat that defense by the employer. But what's your sense about that, Drew?
Well, I think that's right. And we have begun to see wrongful death filings. And in fact, you and I were talking about one that we just saw today, which is the family of a decedent filed a wrongful death suit against Tyson Foods. The very short version of the allegations in that lawsuit are that the worker, who was a food processor, was in a situation where they were not being provided PPE, no training, no distancing. And then the complaint also makes the allegation that the executives or perhaps the staff that's not on the line was sent home to work remotely at around the same time that COVID began to hit. The point of that, I think, as a lawyer, you can draw is you're either treating people in different ways, meaning you understood the threat, but you did nothing for one class. And that is one of the ways that you would argue to get around workers' comp. It's like you were saying earlier, it's a higher standard that you've now pled with respect to the alleged improper acts of the employer.
Right. So, and, I think a lot of times the allegations of the complaint are accurate. I think a lot of times the allegations of the complaint can be defeated, but I think the allegations of the complaint are purposefully crafted so that the claimant can hope to avoid being sent back to the limited workers' comp recovery.
And I think two things are interesting also about this case. First thing, and this is kind of a side issue, is the allegations are that a lot of the processing of pork, which was taking place in that plant, was for export. The point of that being is that was this particular employee's position essential such that they had to be at work when what they're really doing is exporting pork for a foreign market, as compared to feeding the US population, and whether or not that is important. The second issue I think that needs to be taken into account as well is that as we sit here today in October of 2020, we know a lot more about COVID and how it works or doesn't, and some of the things that you can do to help mitigate the risks. Whereas in March and April of this year, there's a heck of a lot less known about how you can or cannot work safely. And I think that's also an issue that if I were a defense attorney for Tyson, that I would consider bringing up.
Right. And I think if I was just an employer in general, I think you are going to have to be checking current regulations put out by OSHA or the CDC or local community guidelines and following them, or making decisions of how you can follow them in your work site for defensive purposes as well as business purposes, commercial purposes, good citizenship purposes, and the like. But I think that you are going to be questioned if you don't do that and measured against it.
Well, and to that point, again, taking Florida as an example, which is our home state, we recently, via our governor, moved to the so-called phase 3 of our plan, our state's plan for reopening. And what I'm predicting is that there will be some argument about whether or not, if the state of Florida declares that we're now in phase 3 and all of the relaxations that that includes, is if that somehow provides some kind of shield to liability. My answer to that is I don't think it does. I don't think that the governor's phasing provides any type of floor or perhaps ceiling to what you should be doing to protect your workers.
I agree with that. I think that it's going to be, what would a reasonable person do in the circumstances in the community? And
we've talked now, I think, about both kind of work comp and how that fits in, and then traditional tort lawsuits that employees may bring. What do you think? We talked about this a few minutes ago, but what do you think about liability under the AIDA and then age claims and national origin claims?
I think that employers should expect to see those types of claims asserted. They can arise in any different context, working backwards, to the extent someone feels that an employer has either articulated or de facto imposed a policy that somehow excludes or emphasizes a person's national origin, that can expose them to a claim. There's been all sorts of political rhetoric about the origin of coronavirus and the pandemic and that sort of thing. I think that ADA is going to surface without question, and there are protections built into the ADA that protect not only disabled workers but workers who are perceived to be disabled. And so employers need to be vigilant about how they implement their policies, who they perceive as covered or not covered, and not play doctor, but rather have discussions with their employees about what the employee can and cannot do and why. And I think that finally, in that same vein, making decisions based on your knowledge about a person's age is not going to be welcomed and probably will be challenged.
And to that point, kind of expounding a little bit, so what I hear you saying, and it makes sense to me, but I want to make sure that everybody who's watching understands too, under the ADA, you're saying make sure that you're not presuming to have the right answer for your employees with respect to whether they should be not working because they're in a particularly susceptible class, which would be both if they have an infirmament, I guess you would say, if they have a pre-existing illness that could make them into a high risk category, just to make sure you're not just dictating to them how that plays out in your workplace is, I think, the first point you're making.
I think that's right. And those of us who operate in the HR space and employment space know that the ADA is a very fact-specific inquiry, or leads to a fact-specific inquiry, and one that involves an interactive process with your employee, and you should engage in that process. You should not make prejudgments about anything.
And it's a similar argument you're making, and concern, I should say, not argument necessarily, with respect to age claims, and that federal law protects people that are 40 and over. And for instance, in Florida, for age claims, the state law doesn't really have a lower limit, as I recall.
Right.
The question simply is, are you discriminating against somebody based on their age?
Based on their age, right.
Right. And again, this goes into what to use a loaded word, we call a chauvinistic employer determination, that a person is in a category such that the employer, don't think the employee should be taking the risk. And that's what you're saying with respect to that type of claim.
I am. And while we're talking about that, and this perhaps comes at it from the opposite perspective, I think it's important to know that the discussion you and I are sharing is one which pertains to only the employee. It does not pertain to the employee's family or others that the employee may be living with. It only pertains to the employee. So if the employee might need an accommodation because of their health, that's one thing. If an employee requests an accommodation because of someone in their residence, that is a different analysis and probably a different result.
But, and you will certainly disagree with me if you do, but if I have, let's take ADA for just a moment. If I, as an employer, find out that one of my employees has a family member who comes down with COVID, and for whatever reason, I make the decision that then means that my employee is not coming back to work for a month, and that obviously impinges upon their income, et cetera, meaning they have a damage of some sort that they can demonstrate. Would that not then give rise to a problem under the ADA?
Not in the current environment, it would not. But the EEOC has spoken to that. But what situation I was referring to is if an employee comes and says, you know, my 85-year-old grandmother is living with me and I don't want to go out and work in the office and then potentially come home and expose her to something that I picked up at work. That, according to the EEOC, is not likely to require accommodation under the ADA.
Right, but to compare and contrast, what I think we're both saying is that the ADA, absent COVID, would have a different result than with COVID.
Correct.
The EEOC coming out and saying we're changing the rules in light of how this disease is spread.
Right, no question about that.
So my point simply is, for those people that are employers, you have to think about ADA COVID and ADA not COVID, and you can get a different result on a very similar fact pattern, just the question of the virus.
Right, right. And in that same vein, there have been recent relaxations by the EEOC, for instance, about, you know, temperature checks and things like that, because while that might in a non-pandemic world be considered a medical exam, it's been designated by the EEOC as being appropriate and not violative of any law.
Right. Okay. With respect to that, I think we've talked about the things that we wanted to talk about for segment 1. Why don't we transition to segment 2?
Fair enough.
Okay.
Thank you. Thank you for watching. Thank you for your time. We appreciate it.
Thank you for joining us for Lowndes Legal Talk. For more information about today's topic or to learn more about our attorneys and practices, please visit lowndes-law.com.